So I'm Kate Falkenstien. I'm one of the lawyers for Mr. Rico. Just wanted to thank you guys for coming, especially from so far away, so many of you, and it's great to have your support. I think, you never know, but I think that went really well. She seems at least open to the claims that Mr. Rico is bringing, and certainly I think the more that the facts come out, the more that people will realize how disturbing this policy is. How much it really does keep people awake. And I think everyone intuitively, once they understand that this is keeping people awake, can understand how that is a very serious violation of people's rights. So, we're just looking forward to getting to the next stage where we can bring those facts out and, show people what's really going on here. And I know that Mr. Rico will be very encouraged that there were so many people here. His primary goal is that he just wants people to hear the story and understand what's going on and feel like the outside world is seeing what's happening in there. And when I tell him that there were, a couple dozen people who came just to hear this hearing, I think he will really feel like this was worth it and like he's being heard. So he can't be here to say thanks, but I know he would if he could. And I'm really grateful too. So if you guys have any questions, I'm happy to.
Could you maybe I can't hear you. Explain some of what the Department of Corrections is arguing and what you are.
Sure. So, what the arguments are basically, and the other side, or why they're arguing it should be dismissed. So, I think they have essentially three. Sorry, is that better? Yeah. I've never really used a microphone before. They have essentially three arguments. They're arguing that the case is moot because Mr. Rico's not in the solitary confinement unit anymore. That argument they didn't make until yesterday morning at like 11 a.m. So, I think if that. There might be, that's why we were talking about whether there should be more briefing about that, because we haven't had any chance to respond to it. So that's sort of the most recent argument. The two arguments that existed in the brief, they're arguing that Mr. Rico can't get any damages, any money, because in order to have damages against a government official, you have to show that the government official should have known that what they were doing was wrong. There was already case law that said you can't do this. And their position, I guess, is that there is a lot of case law that says you can't keep people awake in prison, can't deprive them of sleep. But they're saying, well, there isn't any case that says that you can't use the Guard 1 system to keep people awake, and that you need something like that. But I think that level of specificity is nearly impossible. You could think of a million ways to keep people awake in prison, and you would need a case for every single one, which would never really happen. So given that there's already law saying that you can't keep people awake, that seems to be the main point here from our perspective. Then their other argument is essentially that because the judge in Coleman, related case, already ordered the prison to use Guard 1, surely it can't be illegal, and that this court should essentially defer to the Coleman court and say, well, this has already been settled. The problem there is that basically there are very limited situations in which one set of people suing can stop another set of people from suing about the same thing. Generally, everybody gets their chance to have a day in court, even if they have similar claims to someone else. And Mr. Rico and the other 5 inmates who have brought lawsuits here separately weren't part of that prior Coleman case. The Coleman case that has class representatives, but their classes for mentally ill inmates, and many of the people suing now don't have any sort of mental illness, no propensity to suicide, but they're still being subject to the checks. So I guess our key point is that everybody gets the chance to be heard independently, and just because this has been heard by some other inmates in a sort of different situation in Coleman, it doesn't mean that you can't hear it here. The issue of it being noisy and the issue of the effect of the noise on non-mentally ill people has never been heard, and Mr. Rico deserves the chance to raise that issue separately. So those are basically the key arguments that were at issue in the hearing today.
Are you going to write him?
Yes, definitely. He's already seen the briefs, but we'll write him a kind of a summary of what happened. And I guess eventually we'll get a transcript, so then he can see that too. It's hard since he can't have, he can't be here. I know he would like to see it in person, but that's the best we can do.
Can you email out the transcript to us once you get it?
Because they charge a lot of money for the transcript, you're not allowed to send it for, it's some long number of months. I don't know if it's 3 or 6. Until then, anyone who wants to see it has to pay for it separately. After, whenever that date is, I'd be happy to send it to you, but I'm not allowed to send it to you until it's free. or you can pay for it, but you know it's kind of expensive. That way the court reporter gets paid.
Is there anything else that you think people should know about? You represent other people in these cases?
Yeah, there's 6 cases I know of now in this court, by like 6 independent cases by different inmates. I represent 3 of them, and I've talked to the other 3, but I don't personally represent them just because it's too many cases and they're all about the same thing. There's a pending motion to dismiss in the other 2 that I represent too, and it hasn't been ruled on yet, so perhaps she will decide all of them really at the same time. But if not, there might be another one of these hearings in those other cases. And after that, then we'll get to have discovery finally and find out whatever facts we can about what's really going on here, and that's what we've been working towards. So I'm excited to get to that point.
What would discovery look like?
Well, there's, I guess, a few different things you can get in discovery. You can ask for documents from the other side. So, especially in a case like this, we don't have basically any documents because as an inmate, he doesn't have access to basically anything. So all of the documents are on the other side. So suddenly we'll be able to ask for information about whether people have complained about the Guard 1 policy, how they decided on the Guard 1 policy, whether suicides have actually gone down, those sorts of questions. Basically, any emails or documents you can think of that are related to the case, we would finally have a way to get them. You can also ask like written questions to the other side, called interrogatories. So you can come up with some list of questions. They have to write a written answer, and eventually we can take depositions of people on the other side.
Can you get information about suicides that have been taking place on the Guard 1?
Potentially, we'll see. I mean, we can make a list of documents we want, then they can object to whether those document requests are allowed, and you can then have more litigation about that. So I don't know for sure exactly what we'll ask for or what we will get, but those sorts of things. So certainly, no matter what, he can go forward on the arguments for damages, for money, because like you said, what happened, and if there's an entitlement to money, it doesn't matter that he got out. The question for that is whether he can still move for injunctive relief, which is like asking them to stop doing the policy and so
Stop what?
stop actually doing the checks, right? Like to ask them not just to pay him for what they did before, but to not do it in the future. I don't think the judge formally ruled on that because she didn't issue any like final rulings today. She'll write up her actual rulings, but I think she sort of indicated that if she was going to consider that, she would likely allow us to actually write a written brief about that issue because we haven't had that chance yet, since that issue was only raised like yesterday morning. And I think she seems sympathetic to the concern that he could go back. It's actually already happened once during this case. He was in and then he was out and then he was in again and now he's out again. So it's hard if every time that someone goes out of this unit, then the case has to end. It's hard to ever actually get anyone to consider the merits of the case, since it's necessarily temporary to be in the SHU and the cases move kind of slow. So I think there's a good argument that it should keep going even if he's out of the SHU, but I don't think she's going to rule one way or the other without having heard what we have to say about it. She kind of hinted. Yeah, I agree with that.
And how long do you think it will take before she rules?
So there's no deadline for her, but I would guess like 2 weeks to a month, maybe even a month and a half. If she wants, it could be 6 months, but I would not guess that it would. I would think so, since it seems like she already kind of has her thinking in order, to me.